A warm good evening to friends on the dais and off the dais. At the outset, I have got a strong grievance against my senior counsel that he virtually left nothing for me to say. In fact, each and every point which I have labored through for 2 days has been covered by him. So whatever I say will be nothing short of repetition. His address was so illustrative and educative that, frankly speaking, there is nothing for me to add. And the other problem is, being a chief guest or a last speaker always, it has got its own advantages and disadvantages. The drawback is that, as I said, whatever we want to say has already been said by the earlier speakers. So I can simply wrap up by saying that I have nothing to add except concurring with what my brother said. The other drawback is, the audience also will be a bit impatient, because after having heard for nearly an hour or so, and with the empty stomachs at times, they will not be having the patience to hear. So there are advantages are there, disadvantages are there. But since I have prepared so many points, I have to request you to bear with the repetition. Of course, my experience is different. My experience, as has been said by Parsati, I had been on the bench for 45 years, right from magistrate, assistant session judge, high court judge, and even after that as the president of the State Commission for Consumer Disputes for 5 years. And even now, I am the chairman of the advisory committee on the PD Act cases. I am also chairman of the price fixation committee for purchase of liquor and beer by the state government. I am also the professor of practice in ICFI Law College. So I am trying to keep myself abreast with what's happening, but still, whatever we did is almost old. My information is, dates back in 2018, I retired from the High Court. Much learned counsel used to guide us, and we did something, whatever best we can do. But now, 6-7 years, we are out of touch with what's happening in the legal system. For example, when I went to ICFI Law College, I was called upon to speak about the family laws. I was not aware about the amendments made in 2023 or 22. Then the teacher, that faculty has to tell me, sir, this has been changed now. So I have to cut a sorry figure there. So therefore, our information is very old. And as it is an interactive session, I request that more time should be given for interaction, because we have already heard the pros and cons of the mediation. Hope is a naively denying the problem. Hope against hope. But it is just relentless believing in the existence of solution. There is a solution for that. There is a hope for us. So similarly, in mediation also, the hope is that the matter will be amicably settled to the satisfaction of both the parties. That's very important. When the judiciary was getting clogged with overburden due to heavy pendency, this alternative channels to drain out some of the cases was thought out. There was domestic and international pressure, unique trial, something, all those things are there. Where there's our country, unfortunately, our judiciary was having the infamous reputation, which is even now, is a reputation is that time-consuming, cumbersome, lethargic, all this expensive, all these things are there. But the reasons behind that, Shanti knows and I know. Many of you may not be even knowing the reason for all these things. Because, see, one of my chief justices used to say, you may be having 5,000 cases on your board. Yes, we agree. As a chief justice, I know you are having a 5,000 cases on your board. But what about the litigant? The litigant said, this is only my one case. I'm not bothered about your 4,999 cases, sir. What about my case? I'm having only one case. So he's concerned about his one case, and he's making naturally demands. And even in the Consumer Commission, the law mandates, 6 months, 90 days, 1 year. It's practically impossible. And naturally, when the agitating public demand, we have to cut a sorry figure. As a matter of fact, in Consumer Commission, I had to openly confess that I am unable to raise up to the expectations of the statute, because it says only 60 days, 90 days. It's impossible. As has been said, the reason is, the procedure has to be followed. Any deviation in the procedure, will lead to appeals. these advocates will not leave us. They will carry us up to Supreme Court also, and they will, completely try to smash our orders. They will point even from full stops and commas also. They will dig out. That is because they have got remedies. They are fighting for their clients, and there is a just requirement for them. Otherwise, they will be unethical on their part if they won't fight for their clients. And one more thing, both the parties before the court knows the truth. They know the truth. They are only trying to see whether the judge can make out the truth out of it or not. So it is said, the judge is on trial. The judge is on trial, not the parties. They know. See, when both of them, for example, matrimonial dispute, for example, just I'm telling you, husband and wife know what is really wrong with them. The reasons which are placed before us are not all relevant. The real facts are hidden. The real facts are hidden. Even, I can say, even 498 cases, I did hundreds of cases in the Dowry Prohibition Act. Frankly speaking, not even 1% of the cases are genuine cases of dowry harassment. 15 years after marriage, dowry adagarantarandi. Ever nammutara? Can you believe? Mungur pillal puttaru, naluguru untaru, dowry adiginadu ever namtarandi? But there will be different issue behind that. That issue is hidden from us, and that they want us to dig out. So there is a real problem. Judiciary, and another thing is, even the Law Commission reports are there, Shashi, I think you know, Shanti, that for 1 million population, there should be 50 judges minimum. There is a requirement that 50 judges should be there for some 10 lakhs people. We are having sanction strength of only 21. Out of that 21, 30% at a given point of time are vacant. That means about 15 or 16 judges are to cater to the litigation of more than 10 lakhs population. And population, not only population, the litigation is exploding. Yes, we are very much thankful for all these stakeholders, for bringing a lot of awareness among the society. We are bringing awareness. We are creating so many legal literacy camps, meetings, advocates are going. Madam Nanda was very active with me. I know very well how she used to champion the cause of the people. They used to say, yes, come and fight. Don't, see, one thing is there. Bearing injustice is as sinful as perpetrating injustice. Anyayam bharinchadam kuda chala neramandi. That always we propagate. But unfortunately, when they come to us, to the court, we are unable to do. When I was again in the State Commission, people used to call me to address the consumer organizations. I used to say, I'm sorry, I can't come. Because I can't stare at the eyes of the people and say that come to the Consumer Commission and get your dispute redressed. Just for 5 rupees matter, 10 rupees matter, 100 rupees matter, 1,000 rupees matter, 1 lakh, 1 crore. They have to go around, particularly builders matters, medical negligence, so many cases are there. I had no courage to look at their face and give any speech. Suppose even if one man gets up and asks, sir, my case is pending on your file for the last 4 or 5 years, what are you doing? What answer should I give? Who is responsible? At the cost of repetition, I can say, he says, I'm not bothered about your 5,000 cases. The State Commission, which was supposed to have 5 people, I was the only single man handling the entire cases. That is my headache. This is not his headache. His headache is his case. So therefore, so many factors are there which go into all these things. And to overcome all this, mediation is one of the best methods. As has been already said, better than arbitration, because expenses are many. In fact, while I was Principal DG at Rangareddy, when I said that we'll appoint some some reconciliator or something like arbitrator, then the client openly asked me, sir, we have paid so much court fees and again you want me to pay 1 lakh rupees to that arbitrator, that mediator, whatever you call? Why should I pay that 50,000 rupees or 1 lakh to him? I paid court fees, you decide. What answer can we give? So such things are there. They are all practical difficulties, brother. I know it is very easy to blame, and I, as a judicial officer for so long period, we certainly own. But judges by themselves are not only responsible, there are different stakeholders, procedures. And the person who is having a strong case will not try to delay. But the person with weakness, he will always try to protect the litigation. When I was working in rent controller, the success of a tenant is delay. If an advocate can successfully drag on the eviction matter for 5-6 years, that is success for him. What to do? They want to delay. They used to file some application. They know the result. They know it will be dismissed. With dismiss, Musini akkada datangane High Court undi akkada. This side they'll just cross the Chaurasta and go to High Court and file CRP. And we as High Court just were very magnanimous in admitting and granting stays. That's what is happening, brother. Practical thing. See, let us not hide. They are all our intellectuals. They should know where we stand. Otherwise, what is happening is society is going on blaming the judiciary, advocates, judiciary, this thing, that thing. And lawmakers. Yes, at the drop of a hat, they make the legislation. I can say with due respect in a closed house that many of the legislations are for the galleries, not with a real purpose. Already existing laws are, I think, more than sufficient for catering to any litigation. If you properly interpret a provision, I don't think there's a need for any fresh legislation. But what happens when there's uproar, that Disha matter, that Delhi, that case, rape case, this thing, that thing, Pokso, Gigso, all these things are coming up. They are just, I call knee-jerk reaction. There's a knee-jerk reaction by the lawmakers, and in their wisdom, they make legislations. Unfortunately, they won't have the impact assessment. If they, for example, 138, after 138, lakhs of cases have been filed. Prior to that, they used to come to civil court. 138, they made that amendment, and they said you can get matter disposed of within 6 months, within 1 year, and lakhs of cases were filed. In fact, several special courts were created only to cater to the needs of check bounce cases. Thousands and thousands. But they just make the legislation and leave it. But the impact is on the existing structure. The already crumbling structure will further crumble by these enactments. Again, even with due respect to lawmakers in their wisdom, the recent CPC, CRPC, IPC, they have been amended. I did not find anything much of a change in those things, except for artificial or ornamental changes here and there. But for public, people will thought that now a criminal procedure code has come, whereby we can get justice expeditiously. Where is the expedition? Simply by saying that you dispose of case within 1 year, is it suffice? Does it sufficient? If you take out new CRPC, something is called Bharatiya, something. But what happened? People, laymen, they think, "Bhai, a naya CRPC aa gaya, bhai. As per new CRPC, you are supposed to do early. What are you doing?" But where is the infrastructure, manpower? They are not creating. They are not bothered about that. At least if the existing vacancies are filled up, is more than sufficient. Brother knows how many vacancies are there in the High Court. I think now better, slightly better. Otherwise, less than half. And that night oils which we burn, he is a witness to all those things. How much? Hardly 4 or 5 matters I can, even if I'm so efficient and very, dynamic judge, I can dispose of hardly 4 or 5 matters in a day. But my board will have 200 cases. What to do? If I can post only 10 cases on that day, there's no question of adjournment. Vaida pe vaida, date pe date, tarikh pe tarikh, so many comments are being made. But what to do? On my board, there are 200 cases, and if I won't post 200 cases, the cases will go to 5 years adjournment. If I want to keep my board with 20 cases only and take up 5 matters, yes, I can do that. But the next date of hearing will be 4 or 5 years afterwards. At least for their satisfaction, we have to give nearer dates. 2 months date, 1 month date, 3 months date. Then our board is clogged. We can't do that. Naturally, we have to adjourn. And people will say, tarikh pe tarikh, we are going to the court, advocates are colluding, advocates are not cooperating, judges are not doing, so much things are being said. So therefore, all said and done, this mediation process, I think because he has already elaborately covered, I don't want to trouble you with all the points which has been said. It's one of the best mechanisms. Out of several, when this problem became very uncontrollable, this arbitration and reconciliation was thought of. It is not new. As the brother said, Lord Krishna himself was a mediator. It is not a new concept, but we forgot about that. We forgot about that, but now they are trying to remind us that yes, mediations are there. Even now in villages, if you go, we have certain good people, many more experienced people than judges. Though they may not be knowing the intricacies of law, but they know the humanity, human beings, the mentality of the people, the needs of the society, they know better than we know. Myself and brother will not be knowing so many things which they really know. But they are not bothered, they are not going there. They just want to rush to the court and see, as I said by the Nizamabad case, they want to see that the other brother is harassed. Sometimes small, I can give one example. While I was district judge near Machilipatnam, two sisters, they are twins, they were fighting for a partition. And a lot of rancor, a lot of shouting, court lo vachinappudu a lot of shouting they used to shout. Both are sisters. One sister was saying, పెద్ద చెల్లె మ్యారేజ్లో ఎక్కువ ఆస్తి ఇచ్చేశారు, నాకేమీ లేదు, I have not given sufficient share in my marriage, she was given pushpa kumkuma, stridhana, all that. They were going on shouting. I heard them for nearly 2-3 hearings. And as has rightly been said, the success of a arbitrator, wherever it is to hear patiently, to give ample opportunity to the public to vent out their anger first. Whenever, particularly in matrimonial disputes, whenever I was trying to mediate, they used to shout, husband and wife. My Gumasta will come and say, hey, khamush beta, khamush beta. I used to say, please don't stop them. Let them blurt out. They will have the satisfaction. Nenu na samasyalu judge gariki cheppanu. I told about you to the judge. There is their satisfaction. So let them have that satisfaction. Babu, why do you stop them? All right, see, half an hour for me, we have to. So we will allow them to blurt. So I allowed both the sisters to blurt. It was Machilipatnam, that pure Andhra area, lot of very valuable lands. Then I slowly suggested, Amma, see, both of you have shared that small space in the womb. తల్లి గర్భంలో చిన్న స్థలం మీరు పంచుకున్నారే, ఆ పాలు పంచుకున్నారే, చిన్ననాటి పరిచయాలు పంచుకున్నారే, ఈ చిన్న భూమి గురించి ఎందుకు మీరు కొట్లాడతారు? Why do you fight for this land when you have shared the small space in the womb of your mother? You have shared the milk. What more you want? After all, for this land you are fighting and you are accusing the sister? I don't know, brother, I should not boast myself, but that did miracle. అది ఏంటో వాళ్ళకి సైకాలజికల్ అయిందేమో. నెక్స్ట్ డే ఫీలింగ్ వచ్చేసి, అయ్యా మీరు ఏమైనా చెప్తే మేము ఒప్పుకుంటాము, మీరే ఏదో రాసేయండి మా గురించి అని. So that's how, you see, even mediators, though they are not supposed to, advise or do adjudicatory process, but as brother rightly said, he should be a well-versed, a matured person. In fact, there is a 40-hour training for mediators. As a principal district Rangareddy, we used to train mediators. And brother, you may be knowing, in 1995, when Prabhashankar Mishra was the Chief Justice, I was the Principal Secretary, and people from London came. People were called from London to tell about these processes. And Jubilee Hall lo pedda meeting arrange chesinapudu. So it is not a new thing, it's going on, exploring, but thing is awareness. And now the corporate sector is very crucial, it's the backbone of the economy of the country. And if you indulge in litigation, time-consuming litigation, knowingly or unknowingly, wittingly or unwittingly, you are affecting the economy of the country. So instead of wasting the manpower, money, and all those things on this cumbersome and time-consuming litigation, mediation is the most appropriate place where, as has been rightly said, again at the cost of repetition, you can place all your cards before the table. Openness, open head, open heart. Be very frank. No fear of, as confidentiality is there. Even the nothing said here can be placed before that. All this, brother has said that even the mediator cannot be questioned by even the court also. The court cannot summon him and say, "Bhai, you tell us what happened there." And the party cannot be cross-examined as to what transpired during mediation. So all those safeguards are provided in this mediation. Unlike arbitration, as has been rightly said, arbitration is slightly on a different pedestal. But mediation, is purely informal. Only thing is, a matured person, an experienced person who knows the real human values should be made to mediate. He must have cool temperament, smiling face, a composed mentality, and now and then giving small tips and hints, which at times may go to their head and that may deter them from litigation. For example, when I was chairman of the State Commission for Consumer Disputes, this Apple phones, Apple telephone, some phone. Three brothers from Begum Bazaar brought those three phones at the cost of 83,000 each in those days. I don't know how much it's costing. 83,000 each. Three brothers brought phones from that Begum Bazaar. All Marwadis, well-to-do people. They were not working properly. They went to service center at Secunderabad Patni. And they were going there. That engineer used to say, you leave behind the phone and come tomorrow. They were not, they came, we won't leave the phone. We will be here only. You check the phone before us. And the big company, they were saying, no, we won't do. You leave the phone and go, come tomorrow. So the litigation was going on. Even when I tried to call the engineer and said, Babu, why don't you check the phone before them and tell them, no, sir, we won't do it. It's against our policy. I'm sorry, sir, we can't do that. Let them leave the phone, we'll do it. Then I gave him churka. I said, all right, brother, if you won't do that, I will pass an adverse order against you, and tomorrow I will give it to all the newspapers. And mind it, the reputation of Apple company, how much it will be tarnished. We should not say that, but sometimes we have to. We have to make them see the reason. For that purpose, we have to say that. I said, I will pass an order saying that iPhone, the so famous iPhone, Apple company, that's how they are treating the consumers who brought valuable, costly phones, and when they go to service center, that's how they are treating. That is sufficient for you or tarnishing your reputation and image. Then they said, all right, sir, then from Bangalore somebody came and this thing, that thing. That's how it happened. So mediator, it has to be a lively person, an active person, who should actively participate in the proceedings without exhibiting to be actively participating. He's trained. He's trained. People are, I think some from Bombay or Delhi, when Fakir Chand, some very famous man, was called for training. We had a lot of training sessions here also. Only thing is the mediators has to be very, very sensitive to the needs of the persons. Only then he can, simply being a mute spectator, sometimes will not help. He must now and then give small tips. Okay, it's better you do that. Why don't you ponder over this issue? If you leave the complete ground to them, it will just run like a horse in the jungle without any shackles on them. So therefore, a mediator has to be both proactive as well as sometimes he has to be a mute spectator and give them ample opportunity. You people, corporate sector, will be the best persons, according to me, who can make use of this mediation method, because it saves a lot of not only money, your manpower. If you send your executive to the court, how much time he has to spend? Whole day. He has to come in the morning, sit in the court till evening, and in the evening he used to go away saying that the case has not been taken up. So all these things are there. So the best course open is try to resort to this mediation. Institutions are there. You can approach them and try to solve your disputes and get the best result out of it without there being any problem for you. So the time has come, brothers, to tighten your belts and see that without wasting much time, your time and the time of the court, the matters are settled. Because as has been said by my brother, appeals, revisions, they take a lot of time. And with due respect, even the Supreme Court nowadays is spending a lot of time on hearing bail applications. I should not comment, but as a judge I can say, bail application on the Supreme Court judges is spending so much time. Nothing, no loss for a judge. See, our time is very precious time. The time, see, we follow protocols. You may be sometimes asking, why special protocol to a judge? Why is it special treatment? The reason is, our time is not our time. Our time is your time. If I waste my 10 minutes outside, it is not I am who is losing. It is the client who is losing. The sufferers are the public. So our time is not our time. We are not the masters of our time. We are the slaves of the time. We are only here to help the people. For that, our time is very important. So let us save the time of the judiciary. How best you can contribute to that is in your hands. You can do a lot of things to save the valuable time of the judiciary, whereby they can really concentrate on the matters which really needs to be adjudicated. Now what's happening? I think yesterday we have seen the judgment. After 10 or 12 years, that full special bench was constituted. The reference was made in 2012. After 12 years, yesterday the reference was answered by the light motor vehicle act cases and all that, whether a license is needed for. So how much time they are, 7 judges are sitting there to decide only as to whether a license to drive a goods vehicle can be an LMV or not. For that issue, the wanted that 7 honorable judges heard for days together. They both disposed of the matters. So you can really help the society by helping the judiciary. You must tighten your belts and come out and say, sir, instead of this process, let us have a mediation. And mediation in different stages, as is pre-litigation, court-referred litigation, court also can refer to litigation. CPC has been amended, Section 89 was added. That in my experience, it was not of much use. Similarly, CRPC was amended, Evidence Act was amended, IPC was amended, what is it called? Plea bargaining was introduced. Plea bargaining also was introduced to facilitate early disposal of the cases in criminal matters. That also did not succeed. So all these attempts are not being successful, but if you decide, okay, yes, we can do something to help the society and judiciary indirectly by reducing the litigation, that will go a long way. Because creation of additional courts is all said and done. We know the constraints of the executive. The financial constraints are there. That is also, we are conscious of the fact, because that they cannot do. But within the limited resources, how best we can do? One of the best methods is mediation. That can really solve your problems without any hitch, without any problem. At your convenience, you can go. You can fix the date according to your convenience. Unlike the court will say you come on that day only, you must come on that day only. 10:30 means only 10:30 you must come. So all these restrictions, will not be there in mediation. Flexibility, no rigidity. You can explore all your things properly and get the matters redressed. I think with these few words, I take leave. And once again, I thank the Mr. Moksha and all that they thought that I should come and meet you. This learned gathering is a really privilege for me to have this thing and interactive session.